individuals in the Family Court Act, 205. We're going to start with 205.2, which is terms and parts of court. And this is very similar. It's the same pretty much all across the board with the other statutes. And it's a 4-week session of court and 13 terms of court. So again, 4-week session of court, and there shall be 13 terms of court in a year. And basically, unless otherwise provided in the annual schedule of terms established by the chief administrator of the courts, which shall also specify the dates of such terms. Now, parts of court. A part of court is a designated unit of the court in which specified business of the court is to be conducted by a judge or quasi-judicial officer. There shall be such parts of court mandated by statute as may be authorized from time to time by the chief administrator of the courts. All right, we're going to skip 205.3, individual assignment system. Maybe we'll come back to it. Who knows? Next, 205.4, access to family court proceedings. So the family court is open to the public. Members of the public, including the news, media, shall have access to all courtrooms, lobbies, public waiting areas, and other common areas of family court, otherwise open to individuals having business before the court. Now, the general public or any person may be excluded from a courtroom only if the judge presiding in the courtroom determines on a case-by-case basis, based upon supporting evidence, that such exclusion is warranted in that case. And then there's a list of a bunch of things that the judge can basically make their determination on as to decide whether or not they're going to exclude the public or allow the public in. And they have to determine or using their discretion whether the person is causing or is likely to cause a disruption, or the presence of the person is objected to by one of the parties, including the attorney for the child, for a compelling reason. And then there's less restrictive alternatives to exclusion are unavailable or inappropriate to the circumstances of the particular case, or it's for the orderly and sound administration of justice, the nature of the proceeding, the privacy interests of individuals before the court, and the need for protection of the litigants, in particular children, from harm, requires that some or all the observers be excluded from the courtroom. All right, next, 205.5, privacy of family court records. So, subject to limitations and procedures set by statute and case law, the following shall be permitted access to the pleadings, legal papers, formally filed in a proceeding, findings, decisions, and orders, and subject to the provisions of CPLR 8002, transcribed minutes of any hearing held in the proceeding. So this is who has access to pleadings, legal papers, documents filed in a family court proceeding. And it's the petitioner, the presentment agency, and adult respondents in the family court proceedings and their attorneys. So again, it makes it a point to specify that it's adult respondents. Now, the following part has to do, well, you're probably saying, what about a child respondent? So when a child is either a party to or the child's custody may be affected by the proceeding, then one, the parents or persons legally responsible for the care of that child and their attorneys would have access, or, the guardian ad litem, and attorney for that child can have access. An authorized representative of the Child Protective Agency involved in the proceeding, or the probation service, and also an agency to which custody has been granted by an order of the family court and its attorney. And that's service and filing of motion papers. And let's see, where motions are required to be on notice, the motion shall be made returnable at such hour as the assigned judge directs. At the time of service of the notice of motion, the moving party shall serve copies of all affidavits and briefs upon all of the attorneys for the parties or upon the parties appearing pro se. The answering party shall serve copies of all affidavits and briefs as required by CPLR 2214. Let's see. The assigned judge may determine that at any or all motions in that proceeding shall be orally argued and may direct that moving and responding papers shall be filed with the court prior to the time of argument. And unless oral argument has been requested by a party and permitted by the court or directed by the court, motion papers received by the clerk of the court on or before the return date shall be deemed submitted as of the return date. So again, unless oral argument has been requested by a party and permitted by the court or directed by the court, motion papers received by the clerk of the court on or before the return date shall be deemed submitted as of the return date. All right. Next is conference. In any proceeding, a conference or conferences shall be ordered by the court as required as soon as practicable after the proceeding has been assigned. There's a list of like 11 things to which the matters which may be considered at a conference may include, and that's completion of discovery, filing of motions, argument or hearing of motions, fixing a date for fact-finding and dispositional hearings, clarification and limitation of issues, amendment of pleadings or bills of particular, admissions of fact, stipulations as to admissibility of documents, completion or modification of financial disclosure, possibilities for settlement, and identification of expert and fact witnesses. Now, at the conclusion of a conference, the court shall make a written order including its directions to the parties as well as stipulations of counsel. And alternatively, in the court's discretion, all directions of the court and stipulations of counsel shall be formally placed on the record. Next, submission of orders for signature. So proposed orders. So this I think is important. So with proof of service on all parties, they must be submitted for signature unless otherwise directed by the court within 30 days after the signing and filing of the decision directing that the order be settled or submitted. So again, proposed orders with proof of service on all parties must be submitted for signature unless otherwise directed by the court within 30 days after the signing and filing of the decision directing that the order be settled or submitted. Now, proposed orders in child protective proceedings and permanency hearings, they must be submitted for signature immediately, but in no event later than 14 days of the earlier of the court's oral announcement of its decision or signing and filing of its decision, unless otherwise directed by the family court. So again, there's different time rules when it comes to permanency hearings pursuant to Article 10 and 10A and like child protective proceedings. Those orders have to be submitted for signature immediately, but in no event later than 14 days. Let's see, there's also proposed orders pursuant to Section 1022 of the Family Court Act must be submitted for signature immediately, but in no event later than the next court day. So again, for 1022 of the Family Court Act, it's submitted immediately, but in no event later than the next court day. And then last, orders in termination of parental right proceedings, which is Article 6, or 384B of the Social Services Law, they have to be settled not more than 14 days after the earlier of the family court's oral announcement of its decision or signing and filing of its decision. So again, real quick, generally 30 days, but if it's child protective proceeding or permanency hearings under 10 or 10A, it's immediately, but in no event later than 14 days. If it's for some reason just 1022 of the Family Court Act, it's immediately, but in no event later than the next court day following the removal. And for termination, proceedings in Article 6 or 384B, it's 14 days after the oral announcement of its decision or signing and filing of the decision.
After the signing and filing of the assigned judge and judge's discretion, for custody or visitation, once a hearing or trial is commenced, it shall proceed to conclusion within 90 days. 205.15. Proposed orders have to be submitted to the court within 30 days. After the signing and filing of the decision directing that the order be settled or submitted. In child protective, pursuant to 10 and 10-A, they have to be submitted for signature immediately, then later than 14 days of the earlier of the court's oral announcement of its decision or signing and filing of its decision, unless otherwise directed. They have to be submitted immediately, but in no event later than the next court date following the removal of the child. Orders in termination of parental rights shall not be more than 14 14 days is 10-A, Article 6 in termination of parental rights, and 384B of SSL. The next court date one is for 10/22, and then everything else is 30 days. Okay. But if they ask the question, like, when does the lawyer have to settle the order? The answer would be immediately, but in no event later than as explained. 205.16, motion for judicial determination that reasonable efforts are not required for child enforcement.
Okay, so I wanted to say something else because apparently the fucking Family Court Act can't like figure out what the hell they want to do with anything. And even though you just heard Jacky and me both say that the answer about the proposed orders thing was 30 days, if you go to Family Court Act 217, which I'm looking for right now, and I'm not sure if that's on the test, but hopefully it's not because, well, you're about to hear why I hope it's not. So, 217, this is what it says. Orders, filing, and service. An order shall be in writing and signed with judge signature or initials by judge who made it. The form of the order shall be promulgated by the fucking chief administrator of the courts. An original of an order of the family court shall be filed with the clerk of the family court in the county in which the family court making the order is located. Now, we work at like Supreme Court, so it's weird that whatever. Anyway, then it goes on to say, the court shall file or direct the filing of an order within 20 days of the decision of the court. That's right. That's what it just said. That's what it says. Now, this has not been updated since 1998, and I'm pretty sure the rules are updated constantly. So if I had to guess on this question, I'd probably go with the 30 days.